One aspect on federalism, my lord, which has, I believe, my lord, trying to present a facet before your lordships, which obviously your lordships would have been taken through earlier, but just one aspect of it, my lord, in the context of abrogation of 370. My lord, if your lordships could kindly come to some portions, my lord, of the opening remarks of Dr. Ambedkar, volume 8. Both the opening remarks and the closing remarks, my lord, are at volume 8 of the convenience compilation of documents. PDF page 5. By the way, my lord, the opening remarks presenting the draft constitution was made by Dr. Ambedkar on 4/11/1948. And my lord, the closing remarks came after the draft constitution was drafted on 25/11/1949. But if your lordships kindly come to PDF page 5, my lord, the paragraphs which begin, or just a short paragraph in between. So far, I have explained the form of government under the draft constitution. I will now turn to the other question, namely the form of the constitution.
Very famous speech, very famous extract from Dr. Ambedkar's, yes.
Lord, sir, one reads it again and again, Lord, and one is astounded by the vision of this great man. Two principal forms of the constitution are known to history. One is called unitary and the other federal. The two essential characteristics of a unitary constitution are the supremacy of the central polity and the absence of subsidiary sovereign polities. Contrariwise, a federal constitution is marked by the existence of a central polity and subsidiary polities side by side, and by each being sovereign in the field assigned to it. In other words, federation means the establishment of a dual polity. The draft constitution is a federal constitution as much as it established what may be called a dual polity. This dual polity under the proposed constitution will consist of the union at the center and the states of the periphery, each endowed with sovereign powers to be exercised in the field assigned to them, respectively by the constitution. The dual polity resembles the American constitution. The American polity is also a dual polity. One of it is known as the federal government, and the other states which correspond respectively to the union government and the states government of the draft constitution. Under the American constitution, the federal government is not a mere league of the states, nor are the states administrative units or agencies of the federal government. In the same way, the Indian constitution proposed in the draft constitution not a league of states, nor are the states administrative units or agencies of the union government. Here, however, the similarities between the Indian and the American constitution and the differences that distinguish them are more fundamental and glaring than the similarities between the two. The points of difference between the American Federation and the Indian Federation are mainly two. In the USA, this dual polity is followed by a dual citizenship. In the USA, there is a citizenship of the USA, but there is also a citizenship of the state. No doubt the rigors of this double citizenship are much assuaged by the 14th Amendment to the Constitution of the United States, which prohibits the states from taking away the rights, privileges, and immunities of the citizen of the United States. At the same time, as pointed out by Mr. William Anderson, in certain political matters, including the right to vote and to hold public office, states may and do discriminate in favor of their own citizens. This favoritism goes even farther in many cases. Thus, to obtain employment in the service of a state or local government, one is in most places required to be a local resident or citizen. Similarly, in the licensing of the persons for the practice of such public professions as law and medicine, residence or citizenship in the state is frequently required. And in business where public regulation must necessarily be strict, as in the sale of liquor and of stocks and bonds, similar requirements have been upheld. Each state has also certain rights in its own domain that it holds for the special advantage of its own citizens. Thus, wild game and fish in a sense belong to the state. It is customary for the states to charge higher hunting and fishing license to non-residents than its own citizens. The states also charge non-residents higher tuition in state colleges.
You can skip that.
I'll skip that.
And you
the
can
proposed Indian constitution.
Page 8, internal page, PDF page 7.
Yes, Mr.
The proposed Indian constitution
is a dual polity with a single citizenship. There is only one citizenship for the whole of India.
Then another very important thing which Dr. Ambedkar makes a pointed reference to, if you look at page 8 top, the position in the US,
yes,
each state in America is free to make its own constitution.
Correct.
And therefore the power of altering.
That's right.
And then what, Dr. Ambedkar says, Babasaheb says thereafter at page 8,
Yes.
is this is not true of
True of the proposed Indian
Just read that para, I think that
Yes.
will conclude it.
This is not true of the proposed Indian constitution. No states, at any rate those in part 1, model part 1 as it was originally envisaged, because under the Indian Independence Act, my lord, under section 6. But then that underwent a change, my lord, when it came to the final remarks, have a right to frame its own constitution. The constitution of the union and of the states is a single frame from which neither can get out and within which they must work. So far, I have drawn attention to the difference between the American Federation and the proposed Indian Federation. But there are some other special features of the proposed Indian Federation which mark it off not only from the American Federation, but from all other federations. All federal systems, including the American, are placed in a tight mold of federalism. No matter what the circumstances, it cannot change its form and shape. It can never be unitary. On the other hand, the draft constitution can be both unitary as well as federal according to the requirements of time and circumstances. In normal times, it is framed to work as a federal system, but in times of war, it is so designed as to make it work as though it was a unitary system. Once the president issues a proclamation which he is authorized to do under the provisions of Article 275, my lord, it must have become 356 later, the whole scene can become transformed and the state becomes a unitary state. The union under the proclamation can claim, if it wants, the power to legislate upon any subject, even though it may be in the state list, the power to give directions to the states as to how they should exercise their executive authority in matters which are within their charge, the power to vest authority for any purpose in any officer, and the power to suspend the financial provisions of the Constitution. Such a power of converting itself into a unitary state, no federation possesses. This is one point of difference between the federation proposed in the draft Constitution and all other federations we know of. This is not the only difference between the proposed Indian Federation and other federations. Federalism is described as a weak, if not effete, form of government. There are two weaknesses from which federation is alleged to suffer. One is rigidity and the other is legalism. That these faults are inherent in federalism, there can be no dispute. A federal constitution cannot but be a written constitution, and a written constitution must necessarily be a rigid constitution. A federal constitution means division of the sovereignty by no less a sanction than that of the law of the constitution between the federal government and the states, with two necessary consequences. One, that any invasion by the federal government, the field assigned to the states and vice versa, is a breach of the constitution, and such breach is justiciable matter to be determined by the judiciary alone. This being the nature of federalism, a federal constitution has been found in a pronounced form in the Constitution of the United States of America. Countries which have adopted federalism at a later date have attempted to reduce the disadvantages following from the rigidity and legalism which are inherent there. The example of Australia may well be referred to in this matter. The Australian Constitution has adopted the following means to make its federation less rigid. Then, my lords, in coming to, my lords, the last paragraph beginning there, in assuaging the rigor of rigidity and legalism, the draft constitution follows the Australian plan on a far more extensive scale than has been done in Australia. Like the Australian constitution, it has a long list of subjects for concurrent powers of legislation. Under the Australian constitution, concurrent subjects are 39. Under the draft constitution, they are 37. Following the Australian constitution, there are as many as 6 articles in the draft constitution where the provisions are of a temporary duration and which could be replaced by Parliament at any time by provisions suitable for the Constitution. The biggest advance made by the draft Constitution over the Australian Constitution is in the matter of exclusive powers of legislation vested in Parliament. While the exclusive authority of the Australian Parliament to legislate extends only to about 3 matters, the authority of the Indian Parliament as proposed in the draft Constitution will extend to 91. It has then come to 97, 97 being an omnibus residuary clause. In this way, the draft Constitution has secured the greatest possible elasticity in its federalism, which is supposed to be rigid by nature. It is not enough to say that the draft Constitution follows the Australian Constitution or follows it on a more extensive scale. What is to be noted is that it has added new ways of overcoming the rigidity and legalism inherent in federalism, which are special to it and which are not to be found elsewhere. First is the power given to Parliament to legislate on exclusively provincial,
Go ahead.
in normal times. I refer to Articles 226, 227 and 229. Under Article 226, Parliament can legislate when a subject becomes a matter of national concern as distinguished from purely provincial concern, though the subject is in the state list, provided our solution is passed by the upper chamber, resolution must be, my lord. Upper chamber by 2/3 majority in favor of such exercise of the power by the center. Article 227 gives a similar power to Parliament in a national emergency. Under Article 229, Parliament can exercise the same power if provinces consent to such exercise. Though the last provision also exists in the Australian Constitution, the first two are a special feature of the draft Constitution. The second means adopted to, my lord, my lord, please come to the next page, my lord, PDF 12.
Yes.
Not that the others are not important, my lord, but then to save time, because anyway, your lordships would be going through it. One can therefore safely say that the Indian Federation will not suffer from the faults of rigidity or legalism. Its distinguishing feature is that it is a flexible federation. There is another special feature of the proposed Indian Federation which distinguishes it from other federations. A federation being a dual polity based on divided authority with separate legislative, executive, and judicial powers for each of the two polities is bound to produce diversity in laws, in administration, and in judicial protection. Up to a certain point, this diversity does not matter.
Just skip that a little bit now and then go to the bottom of that page.
Yes.
The draft constitution has sought to forge means and methods whereby India will have federation.
And at the same time, will have uniformity in all basic matters which are essential to maintain the unity of the country.
And then on the next page, Dr. Ambedkar refers to three things: a single judiciary,
uniformity in fundamental laws, civil and criminal,
and all India civil service. That's we can then.
Yeah. No, my lord, the rest of it, my lord, but of course, your lordships would be, with the utmost respect, my lord, I would commend that your lordships have a
I think we have seen the key of
yes,
the key factors, the key features
correct,
of the constitution which make it federal. At the same time,
yes,
preserve the need for
that's right,
a certain degree of uniformity.
That's right,
at the national level.
That's right, my lord. No, my lord, immediately, if your lordships cut the chase to the closing remarks, that's the famous, my lord, speech by Dr. Ambedkar.
1949.
Yes.
Where is that?
That is, my lord, at PDF page 1299, same volume. Yes. So I want to read that. Would you like to read it? No, sir, you can. You can lay emphasis on.
Mr. Giri?
Lord, PDF page 1299. 1299. Starts at 1299. The relevant portion is at 1307.
4160.
My lord?
4160 in red.
Yes, 4160. My lord, see, the relevant portion is again 1307. Continuous page is 4168. Can I read it?
Yes.
There's only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities. It is clear that this view is not only an exaggeration, but is also founded on a misunderstanding of what exactly the Constitution contrives to do. As to the relation between the center and the states, it is necessary to bear in mind the fundamental principle on which it rests. The basic principles of federalism is that the legislative and executive authority is partitioned between the center and the states, not by any law to be made by the center, but by the Constitution itself. This is what Constitution does. The states under our Constitution are in no way dependent upon the center for the legislative or executive authority. The center and the states are co-equal in this matter. It is difficult to see how such a constitution can be called a centralism. It may be that the Constitution assigns to the center too large field for the operation of its legislative and executive authority than is to be found in any other federal constitution. It may be true that the residuary powers are given to the center and not to the states. But these features do not form the essence of federalism. The chief mark of federalism, as I said, lies in the partition of the legislative and executive authority between the center and the units by the Constitution. This is a principle embodied in our Constitution. There can be no mistake about it. It is ever wrong to say that the states have been placed under the center. Center cannot by its own will alter the boundary of the partition. nor can the judiciary, for as has been well said, courts may modify, they cannot replace, they can revise earlier interpretations as new arguments, new points of view are presented, they can shift the dividing line in marginal cases, but there are barriers they cannot pass, definite assignments of power they cannot reallocate, they can give a broadening construction of existing powers, but they cannot assign to one authority powers explicitly granted to another. The first charge of centralization defeating federalism must therefore fail. The second charge is that the center has been given the power to override the state. Then my Lord Dr. Ambedkar says, this charge must be admitted. But before condemning the Constitution for containing such overriding powers, certain considerations must be borne in mind. The first is that these overriding powers do not form the normal feature of the Constitution. Their use and operation are expressly confined to emergencies only. The second consideration is, could we avoid giving overriding powers to the center when an emergency has arisen? Those who do not admit the justification for such overriding powers to the center, even in an emergency, do not seem to have a clear idea of the problem which lies at the root of the matter. The problem is so clearly set out by a writer in that well-known magazine, The Round Table, in its issue of December 1935, that I offer no apology for quoting the following extract from it. Says the writer, political systems are a complex of rights and duties, resting ultimately on the question to whom and to what authority does a citizen owe allegiance. In normal affairs, the question is not present, for the law works smoothly, and a man goes about his business obeying one authority in this set of matters and another authority in that. But in a moment of crisis, a conflict of claims may arise, and it is then apparent that ultimate allegiance cannot be divided. The issue of allegiance cannot be determined in the last resort by a juristic interpretation of statutes. The law must conform to the facts, or so much the worse for the law. When all formalism is stripped away, the bare question is what authority commands the residual loyalty of the citizen? Is it the center of the constitutional state? The solution of this problem depends upon one's answer to this question, which is a crux of the problem. There can be no doubt that in the opinion of the vast majority of the people, the residual loyalty of the citizen in an emergency must be to the center and not to the constituent states, for it is only the center which can work for a common end and for the general interest of the country as a whole. Herein lies the justification for giving to all center certain overriding powers to be used in an emergency. And after all, what is the obligation imposed upon the constituent states with these emergency powers? No more than this, that in an emergency, they should take into consideration alongside their local interests, the opinions and interests of the nation as a whole. Only those who have not understood the problem can complain against it. No, my lord, there is an anguish. Sorry. My lord, see, just one paragraph in the next two lines in the next paragraph, my lord. How the in what was the anxiety, my lord, which he shared, and how prophetic, my lord. Sometimes one feels that so prophetic he could have been. Here I could have ended, but my mind is so full of the future of our country that I feel I ought to take this occasion to give expression to some of my reflections thereon. And 26 January 1950, India will be an independent country. What would happen to her independence? Will she maintain her independence or will she lose it again? This is the first thought that comes to my mind. It is not, sorry.
Yeah, this is Aparajita sent me that. She's
This context.
For this also.
20.
Not that, my lord. These lines which start, the point is, today's context, my lord, the anxiety and the anguish, my lord.
You must complete reading that, Mr. Giri. It's a very interesting passage.
Yes, yes. This is the first thought that comes to my mind. It is not that India was never an independent country. The point is that once she lost the independence she had, will she lose it a second time? It is this thought which makes me most anxious for the future. What perturbs me greatly is the fact that not only India has once before lost her independence, but she lost it by the infidelity and treachery of some of her people. In the invasion of Sindh by Muhammad bin Qasim, the military commanders of Kandahar accepted bribes from the agents of Muhammad bin Qasim and refused to fight on the side of the king. It was Jayachand who invited Muhammad Ghori to invade India and fight against Prithviraj and promised him the help of himself and the Solanki kings. Then, my lords, I'll leave the rest. Next one, will history repeat itself? It is this thought which fills me with anxiety. This anxiety is deepened by the realization of the fact, in addition to our old enemies, in the form of castes and creeds, we are going to have many political parties with diverse and opposing political creeds. Will India place a country above the creed, or will they place creed above the country? I do not know. But this much is certain, that if the parties place creed above country, our independence will be put in jeopardy a second time, and probably we lost forever. This eventuality we must all resolutely guard against. We must be determined to defend our independence with the last drop of our blood. No, my lords, these two speeches made by Dr. Babasaheb Ambedkar, two different points of time, one while presenting the draft constitution, the other after the draft constitution, concluding remarks. There's not much variance, my lord, except to say that the slanting, my lord, if any, in the distribution of power, lawmaking power, my lord, towards the center was justified by Dr. Ambedkar after the constitution was drafted. No, my lord, it is after taking into all this that your lordships have also, my lord, over the years, after 1950, interpreted the constitution, interpreted the federal structure of the constitution. My lord, it has been done in many cases, but for the present, my lord, can you just give the paragraph numbers, my lord, and the PDF page numbers of some of the judgments, my lord, starting with State of Rajasthan versus Union of India. Just give the citation.
Just give us the page,
Yes.
the PDF
My lord,
volume.
volume 26. Volume 26. My lord, 1977 3 SEC 592.
That's okay. We have just give us the PDF volume now.
Yes.
The PDF
My lord, that
page.
is PDF page 54.
At
54.
para.
At paragraph, my lord, just.
So you're giving the PDF page of the relevant paragraph of the beginning of the case, whichever way you want to do it. Just give us the page at which the case begins and the
Yes.
page at which you are stressing the
Yes.
extract.
Yes. PDF 21. PDF 54, my lord, is a relevant paragraph.
All
Three
right.
paragraphs, my lord, from Chief Justice Beck's opinion.
All right. The next.
The next is, my lord, Bommai. Bommai, my lord, is in volume 2, page 2 onwards.
Page and at page.
My lord, that's what. My lord, there are multiple opinions in Bommai, as your lordships would have.
Right. But which are the paragraphs you
My lord, the paragraphs, my lord, can I start with, my lord, in the order in which it is given, my lord,
Sure, no problem.
Justice Pandian's opinion doesn't deal with federalism separately. PDF paragraphs 1 to 9. Therefore, PDF page 2 to 6. Yes. Sorry, PDF page 65, my lord, sorry. PDF page 65, the rest is all, my lord, editorial notes. Paragraphs 1 to 9, and in para 2, he agrees with the conclusions of 1, 2, 4 to 8 of Justice Sawant's opinion, my lord.
All right. Then
Kindly note that, my lord.
yes.
My lord, see, PDF 68, Justice Ahmadi's opinion, para 10 onwards.
Just Ahmadi.
And the relevant portion, my lord, with regard to the federal character of the Constitution is at PDF 69, paragraph 13.
PDF?
69, paragraph 13.
Next.
Para 23 and 24 at PDF 75.
All right, next.
My lord, but para 247 and 248 PDF 206. My lord, the paragraph, my lord, Ramaswamy, Justice Ramaswamy's opinion, para 247 and 248 at PDF 206.
All right, so we've covered both.
My lords, there is a conspectus of the earlier decisions, including Rajasthan and Bomai, in NCT 2,
Yes.
volume 14, PDF 3, paragraph 68 to paragraph 77.
Page.
Paragraph 68 to paragraph 77. Just get the PDF page. PDF NCT. My lord, I'll give the page number in a moment. Volume 14.
Volume?
14. My lord, it doesn't have an SEC citation so far. SEC online is there.
Para 68 to?
Para 68 to para 77.
We'll have an SCR citation. I think all of you must now get into the
I
habit
think-
of again citing SCRs. SCR is now digital. We have already got an ESCR. Hopefully in the next few weeks, we'll have a digital SCR. A digital SCR is exactly as it appears in the volume, while the ESCR, of course, is an electronic copy. And we have updated the head notes right up to probably the last month or so now. I'm not sure exact date, but we are pretty much now abreast. So we have a regular authorized reporting of reporter of the Supreme Court. Because SCR had fallen way behind its times, but now it's up to date. And it also has neutral citations as well.
Oh, that's right, my lord, it has neutral citations.
But we are now moving from an ESCR into a digital SCR. So the digital SCR will have a volume.
It always had neutral citations, Mulaz. It always had. And we were, in fact, used to only cite in the SCR. But then, of course, it was not updated for many.
So I would really encourage all of you to just at least skim through the ESCR and
We'll do that. We'll do that.
and if there are any further improvements to be made, please feel free to let me know because it's a
ESCR in the first 20 years were head notes.
That's right. That's
They
what
were
I said.
outstanding.
Absolutely.
And that is what is missing. They gave complete picture of the case and what your lordship did.
now please have a look at the recent head notes. If there is some improvement, I'll be happy to do it.
My lord, and the corresponding ILRs in the high courts also.
We have revamped our editorial team for the SCR. We have a much broader editorial team. We also have a Center for Research and Planning in the Supreme Court, which is manned by several very talented young people who have been brought in from outside.
Seems that 24 hours are not enough for you.
They're not, Mr. Subbala. When I leave for home, there's so much to be done every evening
I
after
know.
that as well.
Appreciate that.
Some outstanding members of our bar with them, perhaps would
Of course, with pleasure.
likes of Mr. Shankarnarayan cannot, I have no doubt.
But please do have a look at our ESCR and very shortly we'll have the digital SCR. So if there's any change, any improvement, let me know so that we'll do it.
Well, not strictly on this, but then I'll have to, anyway, I thought of referring it in the in another context on which, my lord, I'll do it in a minute or so.
Also, the
But, my
best
lord,
part,
I-
it's a free service. So you can imagine lawyers
Yes.
across the country, from the
Yes.
districts
Yes,
to the high courts, have this
Yes.
free availability of
Yeah.
resource material. Law colleges which can't afford to purchase software,
Correct.
they have this free service. It's searchable, absolutely. Yes.
My lord, earlier days I was a reporter for the ILR, my lord, in the High Court. And one good thing was, my lord, it kept one abreast with all the judgments, my lord, which used. But the numbers were not, it was not so numerous then. But then writing the head note always, my lord, was a task. Giving the head note was always a task, kind of. And one had to send it back to the learned judge, my lord, to get his approval also. Because otherwise, my lord, sometimes one misses out the crux of the judgment then. My lords, one, my lord, I'll just hand it over, kindly permit me. My lord, when Bomai came out, my lord, Bomai was delivered, Mr. Sorabji, my lord, wrote an article which was published in the SEC. My lord, just give 5 copies. My lord, I am not taking your lordships, but when your lordships have the time, just.
Just keep that and put it in the.
Yes. My lord,
Well,
Mr.
just give us
Sorabji argues.
just give us a citation. You don't have
Yes.
to add papers now anymore.
94.3 SEC Journal 1. Just give copies.
1994?
1994 3 SEC Journal 1.
What was Mr. Sorabji's?
My lord, it's relevant, my lord, how Mr. Sorabji argues and persuasively how Justice Sawant's opinion, my lord, should be treated as a majority opinion in Bomai, not on the aspect of federalism. And then my lord says, my lord, this I'll immediately say why it is relevant, my lord, is because it is in Justice Sawant's opinion, my lord, that paragraph 153 comes as a conclusion. And 153.4, my lord, especially, that decisions could be taken, my lord, even irreversible decisions, there is a restriction on irreversible decisions. During the currency of a president's proclamation, till such time as a proclamation, my lord, is approved by both houses of the parliament. That's in para 153.4. I think the learned solicitor has brought your lordship's opinion.
Yes, we saw
notice.
that.
Since the provisions contained, my lord, that is at page 149 of the report. Since the provisions contained in clause 3 of article 356 are intended to be a check on the powers of the president under clause 1 thereof, it will not be permissible for the president to exercise powers under subclause A, B, and C of the latter clause to take irreversible actions till at least both the houses of the parliament have approved of the proclamation. My lord, this should be treated, my lord, in my respectful submission, as the opinion of the bench, as a majority opinion of the bench. My lord, I commend this with great respect. I commend this article of Mr. Sorabji for that purpose, my lord. When your lordships, it's in the beginning itself, my lord. It's a page. My lord, on federalism, I'll just make this proposition, my lord, and leave it before your lordships. I've given, my lord, the relevant paragraphs in the judgments, my lord. I have placed Dr. Ambedkar's opening remarks and the closing remarks. My lord, especially in the last judgment of NCT 2, where your lordships, my lord, had a conspectus of the earlier judgments, my lord, which dealt with federalism. There are 2 or 3 features, my lord, which your lordships have outlined. One is that federalism is a basic feature of the constitution. No, my lords, when your lordships have said that, the federalism, my lord, that is revealed, my lord, from the reading of the constitution as a whole. My lord, please keep 370 for a moment aside. Is, my lord, where the distribution of the legislative powers with the parliament and the state legislatures, and with the slanting, my lord, in favor of the state. The reasons have all been given, my lord. I need not repeat it myself, because your lordships have articulated it so well, my lord, in the earlier judgments. Now, my lords, whatever it is, your lordships will find that 370 constituted when your lordships have a holistic picture of the constitution and the relationship between the union and all the other states. And then if your lordships looked at 370, my lord, put in an area or carved out an area, my lord, which is not in sync with the general federal features of the constitution for the rest of the country, for the union and the rest of the country. Dr. Dhawan, my lord, pointed out other features, my lord, in part 21, 371 onwards. Point is, my lord, over a period of about 25 years, different provisions were introduced, were inserted in the constitution, giving a certain special provisions, my lord, for some of the states, and all therefore an amendment of the constitution and the parliamentary legislation. But point is, my lord, there are 2 or 3 features which emanate out of 370. One is that Parliament requires the consent of the state, the government of the state in relation to matters which are included in list 1 and 3, but not relatable to the instrument of accession. That the consent of the state is required for making applicable certain provision, all provisions of the constitution which have been mentioned in clause D.
Just 1 second. As the consent of the government of the state on list 1 and 3 matters,
Yes.
which matters do not relate to the IOA. That
Yes.
you are right. Yes.
No, my lord, sin.
That is B2.
Yes, B2. D deals with such of the other provisions of the constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify. And then the second proviso, concurrence of the government is necessary. That it has been done repeatedly, my lord, from 1950 onwards is a historical fact. But the point is, my lord, this sets out the relationship between Union and Jammu and Kashmir at a plane. I'm not saying higher or lower, I'm saying at a plane different from the constantly interworking relationship between the Union and all other states in the country, all other states forming part of the Union. My lord, when 370 is abrogated, you have a situation, my lord, which is, my lord, please consider the bifurcation of the state into 2 union territories, my lord, differently. That came about on 31/10/2019. I'm saying, my lord, that when 370 was abrogated by 272, and, my lord, all the provisions of the constitution became eo instanti applicable to the state of Jammu and Kashmir. Jammu and Kashmir, therefore, became a state, my lord, on a complete par with all other states, my lord, in the union insofar as the federal structure is concerned. Even otherwise. Now, my lord, what do the petitioners want? As a solicitor, my lord, was at pains to point out there is a great deal of expansion of rights, my lord, which could be enforced by the persons who reside in the state. But, my lord, what do the petitioners want? They want the 272 and 273 to be set aside and Article 370 to be resurrected. If 370 is resurrected, we would come back to a stage where there is an oddity insofar as the federal structure of the constitution is concerned. J and K would continue to be placed or would once again be placed on a plane different from all the other states of the union. And the federal working relationship which the constitution behoves us to do will meet with a roadblock one way or the other. Lord, I'm not saying that the one principle of administrative law which your lordships have always applied is your lordships would not issue a prerogative writ in setting aside any order or setting aside any action taken by the executive. My lord, if such interference by your lordships resurrects, my lord, a situation that was also not completely legal. My lord, paraphrase it. If setting aside 272 and 273 resurrects Article 370, in my respectful submission, if Article 370 is resurrected, that would also be violative of the basic structure of the Constitution. Yes.
This might be a little too far-fetched because then that would be to postulate that original Article 370 was violative of the
There was a
basic.
challenge. There was a challenge pending here for several years. 1986, my lord, a batch of writ petitions was then made over to the High Court, whether that's still pending. There are people, my lord, who wanted to prosecute it. But of course, my lord, one of the writ petitions challenging 35A is also, my lord,
It was a part of
actually
the
pending.
original constitution, Mr.
I'm saying, my lord, that the federal structure, my lord, I would only, my lord, let me go by the path of least resistance.
Can't invite us to hold in your favor on an unstatable proposition.
No, I'm saying, my lord, that your lordship, let me take the path of least resistance, my lord. The federal structure which emanates, my lord, from 370 is on a different plane from the federal structure.
Mr. Giri, you are not today confronted with a situation where Article 370 is in the Constitution.
I'm saying, my lord, that if there is a resurrection, then, my lord, there is still, my lord, a cause of action.
35A, etc. is on a different.
I understand, my lord. I'm saying, my lord, these.
I think we better wrap up.
I am wrapping it up.
11:25.
My lord, just one aspect on which your lordships wanted an answer, my lord. In Madhav Rao Sidhya, my lord, 1971, 1 SEC 85. Volume 6, PDF. PDF 390. My lord, I'll just give the page number, relevant PDF page numbers and paragraphs. My lord, Chief Justice Hidayatullah's opinion, para 65, PDF 443.
What
Para
volume?
76, PDF 447.
Volume?
My lord, volume 6, my lord, of the case law compilation.
Yes.
It starts, decision starts at PDF page 390.
So what is the proposition you're citing it?
My lord, it's only this, my lord. Your lordship, the solicitor had taken your lordship extensively through Ganpat Rao,
Yes, yes.
which came about later. My lord, the mandamus was issued in Madhav Rao Sindhya, my lord, where after a serious bit of ratiocination, the lordships came to the conclusion, both Chief Justice Hidayatullah and Justice Shah, that the right which is claimed by the petitioners emanates from Article 291, Constitution, and 362, and not from the covenant. And this is same conclusion was arrived at to hold that 363, which is a bar on the courts, my lord, entertaining such disputes, is not attractive because the right claimed by the petitioners is on a right which is generated and frameworked in the Constitution and not in a covenant. That is why a mandamus is issued. We don't have a parallel
One
here.
second. You said that the rights, but Justice Hidayatullah and Justice Shah said that the rights which were claimed by the petitioners originated in Articles 291 and
362,
and not in the covenant.
not from the covenant.
And what is the next? What is the sequitur that?
And therefore, my lords, that 363 was not attractive. 363 has been subsequently repealed, but 363 was not attractive. And therefore, a mandamus was issued. Therefore, my lord, the right claimed by the petitioners was under the Constitution itself. 291 and 362 were repealed. Earlier, my lord, it was only a question of, my lord, withdrawing the recognition of a ruler under 366(22). That was found to be inadequate because 291 and 362 were still intact. That is why, my lord, in the first matter, in Madhav Rao Sidhya's matter, a mandamus was issued. When 291 and 362 were repealed by a constitutional amendment, my lord, no further rights survived. There was no privy purse, my lord, which the right to a privy purse which emanated from the Constitution or embedded in the Constitution. The right was taken away by a constitutional amendment. That's why, my lord, in Ganpat Rao, A challenge to the constitutional amendment on the ground that it violated the basic structure of the constitution was repelled. My lord, petitioners cannot draw any sustenance, my lord, from the ratio of Madhavras India is my respectful submission.
Thank you, Mr.
I am deeply obliged to you.
Thank you, Mr. Giri.